I think the greatest difference when you're arguing as Solicitor General is that the United States is such a repeat player, that it has such long-term institutional interest, that you don't necessarily want to win every case at all costs, because what you might argue in one case might be adverse to the government's interest in another case. Whereas in private practice, you've got a client, an individual or corporation or whatever, you've got a client that needs a result, and you're developing arguments as best you can as to why the client should prevail. When you're arguing for the United States, you often have conflicting interests within that, quote, client itself. The Bureau of Prisons, for example, and the Civil Rights Division might have different views on whether people should be able to sue for police brutality without overcoming certain hurdles. And the Solicitor General has to resolve those conflicting governmental interests. And that makes, I think, the role, being the greatest repeat player before the court, places additional constraints on the Solicitor General. You can't give away the future authority of the United States just because that helps you win a particular case. Well, the most important part of the Solicitor General's work may not be arguing before the court, but making decisions about what the position of the United States is going to be. The Solicitor General will hear from contending forces within the government and make the final decision, subject to being overruled by the President, make a final decision about what the position of the United States is going to be. And that's a very important, very time-consuming, and very difficult function. Then, of course, you have to present that to the court, and they get the last decision. When I headed the Office of Legal Counsel, which I did for 3 years before going to the Solicitor General's office, I didn't realize at the time how wonderful it was that I got to make the final decision. And I remember the transition that July 1, 1996, that weekend when I went from the Office of Legal Counsel down the hall to the Solicitor General's office to take over that office, how frustrating it was that I was going to have to persuade some justice, Justice Kennedy or someone, after I'd already decided what the right answer was. When you head the Office of Legal Counsel, and both Justice Scalia and Chief Justice Rehnquist, who had been head of the Office of Legal Counsel, told me that it was their favorite legal job, for the precise reason that you got to be the final decision maker and make decisions that were binding on the executive branch of the United States. And at the Solicitor General's office, you have to go and make arguments to the court. And I did find that a little frustrating. Also, when you're in the Office of Legal Counsel, you can tell the government to change what it's doing. No, you can't lawfully do X, but you can change it and do Y. Or you can take a proposed statute and say, this is going to be very hard to defend. We need to rewrite it like this. When you're Solicitor General, the law has already been written, the action has already been taken. You already know what your answer is. The answer is the United States should prevail, and you fill out the reasons. Whereas you get to actually make the decision about what the U.S. position is when you're in the Office of Legal Counsel. When a case is accepted by the court, or when the issue arises as to whether to urge the court to accept a case, and you're representing the United States as Solicitor General, you send out the Solicitor General writes to every department of the government that might have an interest, and every division within the Justice Department that might have an interest, and asks for written submissions as to what each component or governmental department thinks the government's position ought to be. And that sometimes results in a meeting in a large conference room with the Solicitor General, where you at least get to resolve the question of what the government's position is going to be. It is sometimes hard to persuade, to make people in government understand that if a cabinet department has a case before the Supreme Court, the secretary of that cabinet department is going to naturally think that the Solicitor General is his or her lawyer. And you often have to remind them or inform them that they are not your client. Your client is the United States. And you have an ongoing obligation to the United States and not merely the preferences of a particular administration that happens to be in power or a particular cabinet department, but the Solicitor General has a fiduciary obligation to the long-range interests of the United States. One of the things that a Solicitor General has to come to terms with is, when do you want to engage the President? And I would say in the 96, 97 term, about 3 times I thought I needed to meet with the President to get a decision at that level about what position we were going to take, and to lay out for the President what the competing considerations were and what my recommendation would be. Sometimes you will get, I remember, I won't identify whether it was me or some other SG, but I know at least one SG has gotten a call from someone in the White House insisting that a particular position be taken, an SG resisting that as taking that position, and being asked, do you accept the fact that, are you aware of the fact that the President gets to overrule your decision? To which the Solicitor General replied, yes, but I was not aware that I was speaking to the President. And the importance of that is, if it's important enough that the President wants to personally engage, that's fine, but you don't let everybody who just calls and says they're the White House try to, influence unduly what positions you're going to take because you do have an obligation to the court, and that works best for the long-term institutional interests of the United States. Oh yes, I have been, in my case, I took the initiative in bringing certain issues before the President. I thought it was a big mistake to try to defend the firing of a white teacher that it was going to be bad for affirmative action because the school board had overreached, and that it was not, the government really could not and should not defend the action of, in this case, it was the Piscataway School Board. But that was such a controversial issue that I wanted to brief the President on why we were going to take the position we were going to take and why we thought it was right, and have him accept that position. I mean, there have been instances where I know of where the SG has taken one position, the Attorney General has disagreed. The two of them have decided to go to the President jointly and make their cases. The President disagreed with the Attorney General, but the court in turn disagreed with the President. And it was all a completely proper process. I mean, I think there are a few decisions that ought to be presidential level decisions because the executive power of the United States is vested in the President. They should be few, and the President should listen carefully to the Solicitor General and what he or she has to say about the best position, but ultimately the President can step into the shoes of any officer of the United States government. Well, I was in the White House actually relatively briefly. I did all the President's pro-choice executive orders, but as a professor at Duke, the weekend before he was being inaugurated in 1993, I spent 3 months in the White House while we were waiting to get an Attorney General confirmed, and then to decide whether I was going to be Solicitor General or head of the Office of Legal Counsel, depending on what the new Attorney General wanted to do about the mix of senior positions. It was actually very useful to spend 3 months in the White House. And ironically, by the time I got to the Solicitor General's office 3 years later, and even as head of the Office of Legal Counsel, having been in the White House helped ensure the independence of those offices. Because people were very reluctant and never did overrule me. They knew I had the administration's best interests at heart. When I told them no, they knew it was because I thought the law just didn't allow us to tell them yes. And I never hesitated, I think, to tell the White House no, but also to tell them we thought hard about alternatives, if there were alternatives to be explored. I thought, for example, that When Ted Olson became Solicitor General, after he won the presidency for George W. Bush by his argument in Bush versus Gore, questions were raised about whether that would compromise the independence of the Solicitor General to have someone who had been the new president's personal lawyer in that role. I thought that exactly backwards, and that Ted Olson was exactly the right choice, and indeed that it was the best choice to protect the independent decision-making process of the Solicitor General's office, because no one was going to second-guess, nobody in the White House or elsewhere in government was going to second-guess Ted Olson's decisions as Solicitor General, because he had the confidence of the president. It worked out. So Ted would actually listen to, be persuaded by the seasoned arguments of veterans of the Solicitor General's office, and basically at almost every instance be able to tell any political folks in the administration to back off and have the confidence of the president. So I think it works in some ways almost backwards from what people think. An attorney general that had enormous independence was Griffin Bell, who had also been President Carter's personal lawyer, because no one in the political branches of the government could interfere with how Griffin Bell and his senior officials of the Justice Department were making their decisions. So I thought in that sense it was actually quite good that I had the experience in the White House before going to the Justice Department. I think it was very helpful to have credibility with inside the administration. In one instance, I was able to go to a cabinet officer and to say, I know it is the momentum in this administration, the policy momentum is to try to bring this issue to the Supreme Court. It would be a mistake. I'm not going to do it. It's a short-term political calculation that is leading to the pressure to take this issue to the Supreme Court. It is not in the long-range interest of the United States. And I didn't get overruled on that. I think because I had a lot of credibility, within the administration. And I think Ted Olson had that same kind of credibility in the George W. Bush administration. Having been in the White House, then in the Office of Legal Counsel, and then in the Solicitor General's office, I became quite convinced that a president should get his legal advice from the Justice Department and not within the White House. I think it is easier to make disinterested decisions and better decisions even if you're just 8 blocks away in the Justice Department. That's a very long distance. Because in the modern White House of any political party, the calculations are much more focused on the short term. I mean, every 20-minute news feed of CNN was the time perspective of people in the White House. I mean, there were people that looked all the way ahead to the evening news. Those people were called visionaries. But when you get out of the White House and 8 blocks away in the Justice Department, you're situated in an institution that has an ongoing identity, that has principles and procedures and policies where 90% of the people don't turn over with change in party administration, if you count all the assistant U.S. attorneys in the department. And there is sort of an institutional ballast there. There is an institutional stability, a sense of precedent and role that I think leads to making better legal decisions. The president needs advisors, and he needs legal advisors on his staff. But I would really argue, if any president asks me, there's one lawyer I really trust, where should that lawyer be in my administration? I would say you need to put her in the Office of Legal Counsel, number one. Your second most trusted lawyer should be the Solicitor General. And your third should be White House counsel. But that's because it's better to have the decisions made in the Justice Department that are going to affect your administration.